Former President Donald Trump rejected a last opportunity to testify at a civil trial where writer E. Jean Carroll accused him of raping her in a department store dressing room and then defaming her by denying it. Attorneys for both parties are set to give closing arguments in the case this morning. Deposition video was released of Trump, who denies Carroll's claims. Here's what he had to say when asked about his knowledge of Carroll.
When you say in here, I don't know this woman and have no idea who she is, even though you're using the present tense, you're referring back to your knowledge as of when she first made the allegation.
I still don't know this woman. I think she's a whack job. I have no idea. I don't know anything about this woman other than what I read in stories and what I hear. I know nothing about her.
So joining us now for more on this is Rebecca Roiphe. She is a New York Law School professor and a CBS News contributor. So the former president chose not to testify, but we did see those deposition tapes. Was that a mistake on his part not to testify?
I really don't think so. I'm sure that his lawyers were advising him not to testify, and that's because on cross-examination, there's a huge risk that any witness would do more harm than good under these circumstances. And I think especially this witness, largely because of his self-confidence, his sense that he has this ability to talk his way out of things. Sometimes that works for him, but sometimes it really doesn't. So I think it was a call, and probably a good call on behalf of his lawyers.
So jury deliberations, they could start today. This is not a criminal trial. It's a civil case. What does the defense and the prosecution need to do to sway the jury? And what will they be considering?
This is going to come down to whom the jury believes, which party the jury thinks is lying. I mean, it's quite as simple as that. Now, the defense is going to, as we were just talking about, because they put on no case, they really do have to rely on their cross-examination. And attorneys for the defense tried to lay out the following claim, essentially, that this witness, that E. Jean Carroll, is lying, and, sort of more moderate version of she's a whack job, that she's lying. They questioned her motivation. Was it politics, money, fame? They questioned her memory. She didn't remember the exact date. And they questioned, what she did during and after this alleged attack. And in all of that, suggesting that this was made up. So the jury's going to receive this information, and then they're going to hear from the attorneys for E. Jean Carroll, who are going to highlight her testimony along with the testimony of the other witnesses, especially those two other women who claimed similar attacks by the former president. And it will come down to a credibility battle.
What is the sort of standard? We know in a criminal case, it's like beyond a reasonable doubt, but what is the standard for a case like this? And I mean, it's got to be challenging because so much time has gone by.
Right. So the standard is much lower. And really, the plaintiffs here really have to prove, simply that it's more likely than not that this is what happened. So it's a much lower standard. But that said, you're right. A huge amount of time has passed. And normally in our justice system, even in the civil justice system, there are time limits on when people can bring claims. And that's because it becomes harder to defend against a claim, not only to bring that claim as time passes. And as we know, New York passed this law giving an additional year for alleged victims of sexual assault to raise their claims. And that has opened up the courtrooms to these sorts of claims, but they present extreme difficulties for the plaintiffs. And it will, again, just come down to whether or not, given this passage of time, given the erosion of memory, and given the jury's understanding that the defense is somewhat limited, given that passage of time, what the jury thinks is more likely than not to have happened.
Okay, so as you know, the former president is facing a number of legal challenges. So I want to ask you about a couple of those. The classified documents case. The New York Times reports that federal prosecutors have the cooperation of a person who has worked for the former president at Mar-a-Lago. How crucial of a role could this person play?
Well, until we know exactly who that person is and what role they played in returning the documents, retaining the documents, it's a little bit hard to know.
Mhm.
But having a cooperating witness is always extremely helpful for the prosecution. And that's because there's certain things that are hard to prove with direct evidence and with even with circumstantial evidence, especially the intent. And because this particular allegation really hinges on what the president was thinking, what he was intending to do with these documents, it is pretty critical to have somebody who can say, he told me this, or I saw him do that. And, again, because we don't know exactly what this person might have heard or seen, it's hard to say just how important that is. But in a case like this, I would think it would be critical to have somebody to help put these puzzle pieces together.
All right. Other big picture that is being put together with many, many puzzle pieces, the investigation into the attack on the Capitol. Dan Scavino and former Vice President Mike Pence have testified in special counsel Jack Smith's investigation into the January 6th attack on the Capitol. What does this say about where the case could be headed?
So this is the culmination of an extremely long legal battle. Just as a reminder, we probably have all heard about it, but there are so many different strands. It's hard to remember all of them at the same time. But there was a long legal battle over whether or not these top advisors would have to testify due to executive privilege. And those legal battles have ended, and the courts have ruled that this inner circle really does have to testify. So that is an indication, not that this is the whole of the case, but rather that this is the sort of conclusion of the case. I wouldn't say that we then have a timeline for knowing exactly when a decision on whether or not to indict will be made, but we do know that we are reaching an end game here at a certain level, because these are the people that you would want to bring in last. Once you have built your case, you want to hear from these people who are the closest to the former president and might have heard what was going on that day and leading up to that day regarding the election, and particularly, again, having to do with intent, because the key question here is, how many of his top advisors had informed him at this point that there was no evidence or no credible evidence of fraud to the extent that it would change the results of this election. If he knew that and he was still pushing, for these events to happen to reverse the consequences of the election, well, that's quite significant.
Yeah, indeed. Rebecca Roiphe, always great having you. Thank you.
Nice talking with you, Anne-Marie.